Hello everyone. Today we are discussing the Protection of Children from Sexual Offences, Pocso Act, 2012. This act was implemented in India in 2012 with the primary objective of protecting children from sexual offences. It is a comprehensive legislation that defines various types of offences, prescribes corresponding punishments, outlines procedures for reporting and recording of offences, details investigation and trial processes, provides for the rehabilitation of child victims, and mandates the establishment of special courts for speedy trials. Under the Pocso Act, 2012, a child is any person below the age of 18 years. This definition is based purely on age and does not depend on gender, maturity, or consent. The Act is gender neutral and applies equally to both male and female children, and even to transgender children. So, any sexual offence committed against a person under 18 years of age falls under the scope of the Pocso Act, regardless of whether the child understood, agreed to, or resisted the act. Now let's look at the types of offences covered under the Pocso Act. This act clearly categorizes various forms of sexual offences against children. Section 3 talks about penetrative sexual assault. This includes any sexual act that involves penetration. Section 5 describes aggravated penetrative sexual assault, which means a more serious offense, like when it's done by someone in a position of trust or authority, or if it causes serious harm. Section 7 defines sexual assault. This means any inappropriate sexual touch without penetration. Section 9 refers to aggravated sexual assault. Again, a more serious version involving certain conditions like abuse of power. Section 11 talks about sexual harassment, which includes showing sexual material, making comments, or gestures with sexual intent. Section 13 deals with the use of a child for pornographic purposes. Section 16 explains abetment, that means helping or encouraging someone to commit any offense under this act. Section 18 is about attempt. Even trying to commit any of these offenses is punishable. So, these sections show that the act is thorough, covering not just physical abuse, but also verbal, visual, and attempted offenses. Sexual assault means touching a child's private parts, like chest, genitals, or buttocks, or forcing the child to touch someone else inappropriately, all done with sexual intent, but without any kind of penetration. It also includes any other physical contact that is inappropriate and sexual in nature, even if it's not on the private parts. The section says that whoever, with sexual intent, touches the vagina, penis, anus or breast of the child or makes the child touch the vagina, penis, anus or breast of such person or any other person, or does any other act with sexual intent which involves physical contact without penetration is said to commit sexual assault. Penetrative sexual assault means any kind of sexual activity that involves penetration of the child's private parts. This includes forcing the child to have oral, vaginal, or anal sex, inserting objects or body parts, like fingers, into the child's private parts, forcing the child to perform or receive such acts. A person is said to commit penetrative sexual assault if they penetrate the penis into the vagina, mouth, urethra, or anus of a child, make the child do the same to them or another person, insert any object or a body part, other than the penis, into the vagina, urethra, or anus of a child, manipulate any part of the child's body to cause such penetration, or apply the mouth to the child's genitals or make the child do so. If sexual assault or penetrative sexual assault is committed by certain categories of people, or under specific aggravating circumstances like during communal violence, causing serious injury, or involving a child under 12 years, it is classified as aggravated sexual assault or aggravated penetrative sexual assault under Sections 9 and 5 of the Pocso Act respectively. These offences carry more severe punishments due to the higher degree of betrayal, harm, or danger involved. This aggravated forms are non-bailable and cognizable offences. Punishments are stricter, including minimum imprisonment of 10 years to life, and in some cases, the death penalty. Under the Pocso Act, if the offender is someone in a position of authority or trust, such as a police officer, a member of the armed forces or security forces, a public servant, management, owner, staff of an institution where the child is, e.g., orphanage, care homes, etc. Staff at places of custody like jails, remand homes, protection homes, or observation homes. Medical personnel in hospitals, public or private, educational institutions, schools, colleges, etc. Members of religious institutions, churches, temples, mosques, any institution providing services to children, such as tuition centers, rehabilitation centers, sports facilities, etc. Then this is a aggravated form of offense, especially due to the breach of trust and the vulnerability of the child. Relatives of the child, by blood, parents, father, mother, siblings, brother, sister, uncles, aunts, cousins. By adoption, any adopted parent or relative. By guardianship, any legal guardian responsible for the child. By marriage, in-laws, father-in-law, mother-in-law, brother-in-law, sister-in-law. By foster care, people who are taking care of the child in a foster care arrangement. Person having a domestic relationship with a parent of the child, ex-spouse, an ex-husband or ex-wife of the child's parent. Live-in partners, partners in a live-in relationship with the child's parent. Joint family members living in a shared household, e.g., uncle or aunt living with the child's parents. Person living in the same or shared household as the child. This includes anyone who lives in the same home as the child and is in close physical proximity to them, like a relative or a domestic worker. Person in a position of trust or authority over the child, doctors and nurses, medical professionals who provide care to the child. Advocates, lawyers who might be advising or representing the child. Coaches and tutors, people involved in the child's sports or academic activities. Counselors, those offering emotional or psychological support to the child. Previously convicted under this law or similar law. If someone has been convicted for a similar offense in the past, either under the Pocso Act or a similar law, any future offense they commit would be treated more seriously. These acts are considered extremely serious due to their cruelty, impact, or abuse of power. Gang assault. When more than one person is involved in the assault, it is called gang-penetrative sexual assault. Each person is individually responsible, no matter their role. Use of weapons or harmful substances. If the offender uses deadly weapons, fire, acid, hot substances, or corrosive chemicals during the assault. Causing severe injury. If the assault causes serious harm to the child's body or sexual organs, it is treated more harshly. Disabling the child. If the assault results in the child becoming mentally or physically disabled, even temporarily, it becomes an aggravated offense. Pregnancy due to assault. If the assault causes the child to become pregnant, it is treated as an aggravated offense. Infection with HIV or disease. If the child gets HIV, AIDS, or any serious infection because of the assault. Causing death. If the assault leads to the death of the child, it is considered one of the most serious crimes under this act. Forcing the child to parade naked. If the child is forced to strip or walk naked in public, it adds humiliation and trauma, making it aggravated. Attempt to murder the child. If the offender tries to kill the child after or during the assault. Giving harmful drugs or chemicals. If someone gives hormones or chemicals to the child to cause early sexual maturity, it is also considered an aggravated sexual offense. Child with mental or physical disability. If the assault is done on a child who has a mental or physical disability, it is considered more serious because the child is more vulnerable. Repeated offenses. If the child is sexually assaulted more than once, by the same person or different persons, it becomes aggravated due to repeated trauma. Child below 12 years. If the victim is a child under 12, the offense is treated more seriously due to the extreme vulnerability of the child. Knowing the child is pregnant. If the offender knows the child is already pregnant and still commits the assault, the offense becomes more serious due to added physical and emotional harm. during communal violence or natural calamities. If the assault happens during communal or sectarian violence, or during natural disasters like floods, earthquakes, etc., it becomes aggravated because such times already put children at greater risk and distress. Under this Act, sexual assault is punishable with imprisonment for a term not less than 3 years, which may extend to 5 years, along with a fine. Aggravated sexual assault is punishable with imprisonment for a term not less than 5 years, which may extend to 7 years, and also includes a fine. Penetrative sexual assault carries a punishment of imprisonment for not less than 10 years, which may extend to life imprisonment, along with a fine. For aggravated penetrative sexual assault, the punishment is rigorous imprisonment for not less than 20 years, which may extend to imprisonment for the remainder of the person's natural life, and may also include a fine. In extreme cases, such as causing the child's death or making the child pregnant, the court may even award the death penalty. Now let me explain sexual harassment. If a person utters any word, makes any sound, uses gestures, shows any object, or displays any part of their body with sexual intent towards a child or makes a child to do the same vice versa, it is the offense of sexual harassment. If a person repeatedly and constantly follows, watches, or tries to contact a child, either directly or through electronic, digital, or any other means, it is considered sexual harassment under the Pocso Act. If a person shows any object to a child in any form or media for pornographic purposes, entices the child for such purposes, or provides gratification for such acts, it constitutes sexual harassment. If a person threatens to use, depict, or exhibit any part of the child's body or involve the child in a sexual act in any form of media, real or fabricated, through electronic, film, digital, or any other mode, it is considered sexual harassment. Use of child for pornographic purposes. Prohibition of child pornography. It is illegal to create, produce, or distribute any form of pornographic material that involves a child. This includes any form of media, such as pictures, videos, or digital content, where a child is shown engaged in sexually explicit acts. Possession and viewing. Possessing or viewing such material is also a criminal act, even if the material was not created by the person who possesses it. This includes storing or distributing such content. Punishment. Anyone found guilty of child pornography can face rigorous imprisonment of up to 5 years and may also be fined. In cases where the offense is more severe, such as the production of child pornography, the punishment can extend to life imprisonment. If a person helps, encourages, or supports someone else to commit an offense under the Pocso Act, it is called abetment. This includes instigating someone to commit the offense, conspiring, planning together, to commit the offense, helping in the act, either before, during, or after the offense. Checkmark punishment. The person who abets an offense will get the same punishment as if they had committed the offense themselves. Small diamond Section 18 attempt to commit an offense. If someone tries to commit an offense under the Pocso Act but fails or is stopped, it is still punishable as an attempt. Checkmark punishment. The person will be punished with up to half the punishment prescribed for the actual offense. For example, if the full offense has a punishment of 10 years, the attempt may lead to up to 5 years of imprisonment. Who can report the offense? The child themselves or anyone knowing about an offense can report, and when to report an offense can be reported either before the offense or after the offense. Such offenses can be reported at the local police station or Special Juvenile Police Unit or 1098 Child Helpline of Pocso e-box that is provided on website of NCPCR. In cases of such complaints, privacy of the complainant and the child is always respected. Reporting with a good intention even if the same goes false is legally protected unless this is misused. Reporting is not an option. It is mandatory. Non-reporting is punishable. 6 months to 1 year with fine. Law does not allow settlement. When a report is made, it must be entered in writing, assigned an entry number, read back to the informant, and recorded in an official register. If the report is made by a child, it must be recorded in simple, non-legal language the child understands, with the help of a translator or interpreter if necessary. If the police suspect that the child is in need of care and protection, they are obligated to take immediate steps, such as placing the child in a shelter home or hospital within 24 hours, and inform both the Child Welfare Committee and the Special Court or Court of Session within the same time frame. As per Section 24, the child's statement should be recorded at their residence or a place of their choice, preferably by a woman police officer not below the rank of sub-inspector. The officer must not be in uniform, and the child must not come into contact with the accused or be detained overnight at the police station. The child's identity must be protected from media exposure unless permitted by the court. The statement should be taken in the presence of the child's parents or a trusted person, and if needed, a qualified interpreter or special educator must be present, especially in cases involving children with disabilities. Audiovisual recording is encouraged, and the magistrate must record the statement as spoken by the child, without the presence of the accused's advocate. Documents required under Section 207 of the CRPC must be provided to the child or the guardian after the final police report is filed.
The child who is abused must be given a medical examination at the earliest possible time, even if no first information report or police complaint has been made. This examination must follow the rules given under Section 164A of the Criminal Procedure Code, CRPC. If the child is a girl, the exam must be done by a woman doctor. During the examination, a parent or a trusted person chosen by the child should be present. If no trusted person is available, a woman chosen by the head of the hospital must be there. If a doctor or nurse needs to examine or treat a child for medical reasons and they have permission from the child's parents or guardian, it will not be considered sexual assault, even if the treatment involves touching private parts. This rule protects medical professionals from false accusations while doing their job. It applies during things like physical checkups, surgeries, or treating injuries and infections in private areas. As long as the treatment is necessary and there is proper consent, the doctor or nurse is not breaking the law under Sections 3 to 13 of this Act. Under the Pocso Act, the usual legal rule of innocent until proven guilty is reversed. In these cases, the accused is presumed to be guilty unless they can prove otherwise. This means the burden of proof lies with the accused person, not the victim or prosecution. It is the responsibility of the accused to show that they did not commit the crime. This special provision is meant to provide stronger protection to children in sexual offense cases. Section 35 Timely Trial. The child's statement must be recorded within 30 days after the court begins hearing the case. The whole trial should be finished within 1 year, as far as possible. This is to ensure justice is delivered quickly. Section 36 No face-to-face with accused. The child should not have to see the accused while giving their statement. The court can use video conferencing, curtains, or one-way mirrors to protect the child from trauma or fear. Section 37 In-camera trials. Trials are held in private, not in open court, to protect the child's privacy. Parents or trusted persons can stay with the child for support. If needed, the court can also record the child's statement outside the courtroom in a safe and comfortable setting. Section 38 of the Pocso Act says that the court can take help from interpreters, translators, or experts while recording a child's statement. If the child has a disability, special educators or communicators can also be called to help the child understand and speak clearly. Section 40 gives the child the right to have a lawyer. The child's family or guardian can choose a lawyer to support the child during the case. If they cannot afford one, the Legal Services Authority will provide a lawyer for free.